Good evening, everybody. Thanks very much for coming. As you may have heard a few months ago, the Supreme Court said something about marriage and said something about our Constitution. It was in June. The court decided the case of Obergefell versus Hodges and related cases that were bundled up with that lead case. In that case, the court didn't say just merely something about these things. They said some things very, very new about marriage and some things very, very new about our Constitution. As to marriage, the court set forth a definition that, as Justice Kennedy acknowledged, and clearly in his opinion, was at odds with a once universal, nearly seemingly uncontroversial definition of marriage. As he noted, the traditional definition of marriage, again uncontroversial, was the lifelong union of a man and a woman. Now, this definition, however brief, involved at least 5 stark, naked discriminations. The first discrimination is it must be a union. Marriage involves a coordination, a bilateral coordination at least, not just concurrent or parallel action. It must be a joint or a mutual enterprise. Stated otherwise, John can marry Nancy only if Nancy marries John, and Nancy can marry John only if John marries Nancy. Second, marriage must involve natural persons, not artificial persons, as we say in the law, like corporations or not-for-profit corporations like the University of Dallas. I apologize for this joke, but it just came to me before I started talking. Some of you, I can't resist. Some of you may be under the impression that the reason the University of Dallas cannot marry is because it's the ugliest campus in America. Too ugly to marry. Don't put that face up on eHarmony. No one wants to see that. But I have reason to believe that even if the University of Dallas had the stunning good looks of SMU, that magical, mystical babe down in Dallas, even then the University of Dallas would be disqualified, incapable of forming something that our laws or our culture would recognize as a marriage. Third, marriage discriminates on the did discriminate on the basis of number. The number 2 having been reached, being one more than the number 1, one less than the number 3. Some of you know the reference. Only 2. 1 is not enough, 3 is too many. Fourth discrimination, the one at issue in Obergefell. One of those persons must be male, and one of those persons must be female. And the 5th discrimination is that it has to be of indefinite duration. It has no shelf life, no expiration date. Marriage lasts indefinitely until something substantial or significant intervenes, death or divorce. But again, 3 months ago, our Supreme Court said that one of those 5 discriminations is no longer necessary and no longer proper. As to the Constitution, the Supreme Court also said some very new things. In some, it said that this new definition, which wrenches the 4th discrimination of the 5 out of it, was not only permitted by our Constitution, but required by it, such that every state in the Union, as well as the United States, must adopt this definition of marriage that no longer includes male-female as a necessary component. Now, this too was quite new, radically new. Prior to 1968 or so, there is no record of anyone anywhere saying that our Constitution compels the states to jettison one of the 5 elements of the definition of marriage. And indeed, when the claim that was vindicated in Obergefell first came before the court in 1972, the justices unanimously and summarily rejected it in these words: the claim presents no substantial federal question. In layman's terms, you can't be serious. This is not a serious question or a substantial question. But 3 months ago, a majority of the Supreme Court said, actually, we are serious. And the Constitution does indeed require that the states jettison this fourth of the discriminations in the traditional definition of marriage. Now, to persons familiar with the old marriage and accustomed to the old Constitution, the Obergefell decision, both its new definition of marriage and its interpretation of the Constitution, might seem not only revolutionary, but positively bewildering. But this evening, I'd like to sketch the ways in which the new marriage and the new Constitution are in some respects something rather old, reflect some ideas that have been well developed in our constitutional tradition over the past several decades. Now, I've said that the very definition of this thing known as marriage has these 5 discriminations. Union, natural persons, 2, and only 2, 1 male, 1 female, or gender diversity, and indefinite duration. Are these arbitrary distinctions? Is there some arbitrary, whimsical exclusion of all manner of human arrangements from this thing called marriage? Multiple, countless human interactions, good and wonderful things don't qualify as marriage given the strictness of those 5 naked discriminations. So the question is are these discriminations, these definitional discriminations, are they arbitrary? There is, I think, only one possible defense of this thing called marriage. And that is what was once understood to be its principal purpose, offspring. If you think that marriage's principal purpose is offspring, then the 5 discriminations seem to have some defense, maybe even make sense. Marriage is a union because babies require a union. They're a composite being. Natural persons are necessary because corporations, even the University of Dallas, cannot participate in procreation. They do not have offspring. 2 persons are necessary because the composite, we are effectively a bi-sex organism. 1 male and 1 female for the exact same reason. And the indefinite duration arises because the purpose of marriage isn't merely the procreation, but also the joint education of offspring. And the indefinite character of the needs of children leads to the indefinite duration of marriage. Those of you in my 1311 class, you should know this reference to Hamilton in Federalist 23. That much for the same reason, the Hamilton said that Congress needs an indefinite power of taxation because the demands of national security are indefinite in their extent. So too, marriage needs an indefinite duration because the needs of offspring can be indefinite in their extent, including having special needs, children with special needs, including children who, when they themselves have children with special needs, and several other things that make it such that caring for your own offspring is something that may not ever end. And so it's good for good. Yes. Don't have offspring, Dr. Upham said tonight. No, I didn't say that. I just said it's like really, it can be really, really hard. Okay. I should mention just a word here about the numerical issue, because there's some confusion about that. You may know that in the history of the world there is great debate, extensive debate, on the issue of polygamy versus monogamy, and it's probable that the majority of cultures have had polygamy. That doesn't affect the definition because polygamy is multiple marriages. It's concurrent marriages, not 3-person marriages. The word polygamy means multiple marriages. The 2 wives of the same husband, or the 3, do not marry each other. So another way to describe polygamy is concurrent marriages. Now, as you may know, the foundation for dismantling the definition of marriage was already laid decades ago insofar as the end of marriage, offspring, was obscured both in practice and in speech. Well, at first, with contraception and its promotion, the challenge was to whether every marital act must be for offspring. Very quickly, the culture began to accept not only that marriages, entire marriages, could be without offspring, that was an appropriate thing to aspire to. The companionate marriage that became accepted and often celebrated in the beginning of the 1920s. For one particular and poignant instance of such a marriage, which presents both its beauty and I think also its limitations, I highly recommend the autobiographical book A Severe Mercy by Sheldon Van Auken. There's a movie coming out about that apparently too. I was just talking to a screenwriter about it. In the popular mind, then, marriage began to be seen primarily as romantic partnership and only incidentally, if at all, as fundamentally a procreative enterprise. The stage was set for one of the most profound legal revolutions, more profound, I think, than Obergefell, the no-fault divorce revolution of the 1970s. Now, under the old regime, that marriage is for children who have indefinite and deep needs, the idea that marriage could be dissolved by a unilateral, even casual decision of one of the spouses seemed rather strange, if not highly incongruous. But under the new marriage, as understood as a romantic partnership primarily, it made a lot more sense. A half-century ago, 1965, well before most of you were born, the Supreme Court all but vindicated the new marriage in 2 ways. First, it struck down as unconstitutional and according to some of the justices, irrational and silly, a Connecticut statute that prohibited contraception even among married people. Moreover, in the course of reaching that legal conclusion, the court made a statement about what marriage is, authored by Justice William Douglas, who was, as the little joke goes, one of those guys who liked marriage so much he tried it 4 times. Marriage is a coming together, for better or for worse, hopefully enduring. Don't count on it. And intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faith, a bilateral loyalty, not commercial or social projects. Marriage is a 2-person thing, by using the word bilateral and otherwise. Marriage is about coupling. Offspring don't find any place in this definition. Now, once stripped of its end, its telos, which, as I argued, is the only thing that can make the 5 discriminations of marriage at all intelligible or defensible, the way was open for the challenge that was successful ultimately in Obergefell. Because the marital purpose explained the marital definition. But once the marital purpose was put aside, the marital definition, understandably, appeared arbitrary, capricious, if not downright mean. What did the court say that was not so new about the Constitution? Now, the court, in its opinion, acknowledged, of course, that no one thought this was marriage until very recently. So how could an amendment, a century and a half old, give rise to a duty of the states to accept this very new definition? Well, the court in Obergefell said some things that may seem radical, again, to those of you unfamiliar with some of the more recent developments of constitutional law. The court said first that the liberty secured by the 14th Amendment is not static but dynamic, subject to redefinition in each historical age. And second, the court indicated that the Supreme Court itself is the authoritative interpreter of what the age wants, the authentic discerner of the spirit of the age, the zeitgeist. Here's what Justice Kennedy wrote. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom, and so they entrusted to future generations a charter protecting the right of all persons to enjoy liberty as we learn its meaning. When new insights reveal discord between the Constitution's meaning and a received legal stricture, a claim to liberty must be addressed. Now, both of these legal claims might seem strange. Historicist, liberty ever being redefined by times. And secondly, the authority of the court to be the discerner of the times. Still, the court did not invent this type of reasoning last June. The Supreme Court has long held, for almost a century, that constitutional liberty can change with the times. First in the area of procedural rights, then in the area of economic rights and speech rights, progressive jurists openly repudiated a static reading of constitutional liberty in favor of a progressive historical approach. Accordingly, in 1934, a bare progressive majority of the court upheld a law that the framers of the Constitution almost certainly would have held as unconstitutional. And in upholding that law, the court said emphatically, we deny that what the provisions of the Constitution meant to the vision of that day, it must mean to the vision of our time. So you'll see there that the court says that every age has its own vision. It's a temporal vision, and the Constitution will change meaning based upon a new set of eyeglasses, if you will, even though those eyeglasses are going to show very different things. That's not a very good metaphor. Well, sorry. As the court emphatically said, if by that statement that what the Constitution meant at the time of its adoption it means today, it's intended to say that the great clauses of that Constitution must be confined to the interpretation which the framers, with the conditions and outlook of their time, would have placed upon them, the statement carries its own refutation. In other words, all of you who are originalists, just by opening your mouths, you refute yourselves. The Constitution should mean what the framers thought it meant. Surely you can't be serious. Moreover, in those cases, and there are multiple, that was probably the most stark example, the court plainly assumed that it had some role in discerning what the vision of our time, what those times might mean. On the other hand, there is something truly new in Obergefell, and we should not overstate the antiquity, let alone the inevitability of Obergefell. Obergefell represents a new type of change. It did not attack the telos, or end of marriage. Rather, it took issue with the very definition itself. And I'm still I'm an amateur Aristotelian. I'm not sure whether it's material, formal, or efficient. Maybe a little of all in terms of the male-female. But those causes can be redefined, and that was something new. Moreover, this new definition was adopted in the face of express, well-organized protest and opposition. There was nothing accidental here. There was no gradual general change in public mores, largely unopposed. So, for instance, in terms of the general acceptance of contraception between 1900 and 1950 in American culture, outside of Roman Catholic circles, there doesn't seem to be evidence of much fight at all. And even within Roman Catholic circles, as we know, when the issue was joined, there didn't seem to be much fight either, unfortunately, from my perspective. Similarly, the triumph of no-fault divorce was not a fierce-pitched battle. The laws were passed in conservative as well as liberal states in a matter of a little over a decade. Not so with this new definition of marriage. There certainly was known, public, organized opposition. There were citizens who protested, who registered their opposition in legislative votes and in referenda. Something else, another aspect of this that's quite radical. In those prior cases, for the most part, the Supreme Court, when it said we know what the spirit of the times means, they did not presume to act as the initiator of change, but more of a ratifier, more of an acceptor of change. Most of those cases, the court was upholding statutes that had been passed through the legislative process. This case, Obergefell, the court was striking down laws that were passed through the democratic process. In this way, the court acted not so much as a ratifier of the movement of history, but as part of the avant-garde. Their job was not to accept the day, but to hasten the day. In some respects, then, Obergefell should not be interpreted as just another slide down a slope or a slide up a slope, depending on your perspective, but a step, maybe even a big step forward or backward or upward or downward, depending on your perspective. But a step, if not a leap, not just simply a slide. So what then is our future? Note that the court said that the definition of marriage was once something, is now something else. And we, under our constitutional authority, have a right to determine what the new definition is. And the court's general holding about liberty doesn't simply apply to marriage, it applies to any other purported right. Well, the court is currently deeply divided over its new role, its new claim that it is the authentic interpreter of the zeitgeist. 5-4. On that court, of those 9 justices, 3 of them, 2 of them in the majority, 1 of them in dissent, are well over the age of 70 and were born during the Great Depression. It is highly probable that the next president of the United States will have an opportunity to replace 1, 2, or 3 of those justices. If that's true, the next election will largely determine whether the Supreme Court will continue to take us on its journey through history. If the next president appoints justices like Justice Kennedy and Justice Ginsburg, a majority, if not a supermajority of the justices, will endorse the idea of the court as the avant-garde of historical change. What then will be our future? Well, as they say, the journey is the destination. Or as I frequently tell students, adapting the words of Forrest Gump, history is like a box of chocolates. You never know what you're going to get. Thanks very much. Oh, yes. Buy my book. Buy books.